Welcome to Navigating Receiverships, a podcast from the Commercial Receivers Association, focused on building a better understanding of what brings companies into receivership, what happens in receivership, what makes them unique, some alternatives to receiverships, and ultimately, what happens to the business as the receivership is closed out. I'm one of your hosts, Eric Morcheski, CRA board member and CEO of Nimble Strategies.
Good morning, good afternoon, whatever time it is when you're watching this, and thank you for joining us on one more episode of Navigating Receiverships. We're very happy and honored today to have as our interviewee, Matt McKinlay of Ampleo. I will give Matt a minute to talk about his work at Ampleo and the company itself, but what I know, it's a top-flight financial restructuring firm, also supplies CFO services on full-time or fractional bases. A lot of that deals in turnarounds. But before I go too far into it, just say welcome to you, Matt, and thank you for joining us.
Thanks a lot, Eric. Great to be here, and I appreciate the invitation. I feel underdressed.
Oh, you're not. I had to go to
here.
court this morning. Otherwise, I would have been dressed differently. So I apologize for the formality. So, Matt, why don't you just take a minute and let us know a little bit about Ampleo and about your practice?
Sure. I'm Matt McKinlay. I'm the managing director of the Turnaround and Restructuring division for Ampleo. As you mentioned, Eric, Ampleo's a C-suite service provider. And my role is to supervise and provide service for companies that are in a state of disarray, distress, insolvency. In fulfilling that role, we do a lot of state court receiverships. I just added it up this morning. We've got 8 pending now in 4 different states. And I've got a team of 12 turnaround professionals that staff these. And Ampleo itself has about 140 consultants total. Most of our work is Intermountain and Pacific Northwest, but we do look beyond that and do some work. I think we have probably done work in all 50 states now.
Well, I'm sure with that background, there's a lot of potential case studies. I know that, we seem in receivership. We get some routine things, but we get a lot of strange things. And one of the stranger cases is one I think that we'll talk about today, if that's okay with you. And it's one that when you told me what it was, if I were on the receiving end of that call, I would have probably started immediately thinking of ways in which I can politely decline, because it seems like it will be fraught with issues. And so what we're going to talk about today, and there are a few unique topics that come up in this context, but I believe we're going to talk about a case involving a landfill that has above ground issues with regards to items that require disposal, and below ground issues that deals with potential water contamination, which is coupled with a fight amongst the owners and a cash shortfall. So if you put that all together, it sounds great. It sounds like a situation where, maybe you don't get paid, but you're definitely going to get pursued by the government and on the regulatory side. And who knows whether or not that leads to personal liability. So we'll try to unpack that a little bit.
Yeah.
But before we do it, why don't you give us like a general overview of what this case entailed and how it is that it reached you in the first place?
Yeah, Eric, you're right. It's got all the makings of a case nobody wants. And in determining whether to accept this case, we were sure to put all the protections in that we needed to be sure that we were going to get paid, protected from any potential personal liability. And we'll talk a little bit about that. But you're right. This is a landfill that's operating or was operating in Idaho. The operators were operating the landfill under a conditional use permit that was granted by the county, and certainly, as all landfills are, was highly regulated. In November of last year, the county pulled the conditional use permit or revoked it and effectively shut the landfill down. That, of course, caused significant cash constraints. It caused significant disputes by the owner's members. It caused concern by the senior secured lender, who, of course, is looking to get paid. And it caused unrest by employees who now suddenly don't have a job. So To remedy the situation, a subset of the company's owners moved to the court for the appointment of a receiver, and my team was installed as receiver. We were appointed in September, so what, 3 months or so ago, 2 or 3 months ago, and tasked with containing the environmental issues that are occurring. We were tasked with trying to protect the public good. As you mentioned, there are significant environmental issues here. So we want to be sure that nothing is leaching into the water system that would contaminate the water, that would put in harm the public. And of course, all the while, we're talking with the county on steps that need to occur to reinstate the conditional use permit. We're talking with the Department of Environmental Quality. We're talking to the senior secured lender. We're talking with all of the members, and we're talking with prospective buyers. We believe that the most plausible outcome here is a prompt sale to an actual landfill operator that can help remediate these issues. And I think all of our stakeholders are at least aligned in that objective. So we've been actively marketing the property, negotiating significantly with prospective buyer, and we're almost there.
So I'm curious as an initial matter on the case intake process, because if you are an operator of a landfill, even if you have a pile of cash sitting there, if your conditional use permit gets pulled, if you're determined to have potentially invaded the water supply, when you have a pile of cash, that's a big problem. In that circumstance, you have to do studies, you got to dig holes, you're going to do soil testing. There's just a whole host of things. When you have that situation and you don't have any money, and maybe the operation itself is dysfunctional, how do you pitch that internally at Amplēo to say, look what I got. This is great, right? Let's jump in.
Well, we were very careful when drafting the form of proposed order appointing us to include language that said the receiver is no way personally liable for any act or omission. We've got some pretty strong language and protections there that we're satisfied with, but it was certainly a concern. I will note that there is some, I won't call it remediation, I'll call it precautionary work that's occurring on site that certain parties have agreed to fund to ensure that the situation doesn't go from bad to worse. And the DEQ, the Department of Environmental Quality, is on site weekly to monitor that process. As it sits now, they're satisfied that it's not getting worse. And I think as long as it remains in that state, they won't take aggressive action. But we're hopeful with snow likely on the horizon and some of the erosion that comes to these the landfill cells. We're hopeful that doesn't deteriorate, but that's where it stands today.
Okay, so what is, if you know, the type of material that is giving you the problem here in terms, because this was a landfill, everyone knew there was going to be landfill matter deposited there, but something has arrived on site that has created a concern that may not have been foreseen previously. What is that, and how did that kind of arise as you understand it?
Yeah, well, two primary issues. This is a dry goods landfill that accepted tires. So as we sit here today, there are 300,000, they call them tire equivalents. When you drive around and look at the landfill, you'll see actual tires in their native state, and you'll also see rubber shards that have been processed. This is a process where the steel belts have been pulled from the tires, and a shredder has pulled these tires out into small bite-sized chunks, so to speak. And there are 300,000 tire equivalents on site, and those tires are giving the county concern. They're above ground. They're not buried. They're worried that should they start on fire, that would provide some real air quality issues. Luckily, we're past the fire season here in Idaho, so that concern is is smaller. But there's the concern now is that any rainfall or snow pulls leachate down into the water table and contaminates the water system. So that's a concern. And then on the other side of the landfill, there are traditional dry goods cells where typical waste, household waste or business waste has been hauled to the site. Big trucks have pushed dirt and soil over the top of this refuse. And just as landfills tend to erode over time, it exposes some of this trash into the environment. And the concern is that some of those cells haven't been properly lined or covered. And the risk is that some of that contamination makes its way into into the water.
So with a landfill full of tires, is there any capital, or did you all evaluate, is there any reclamation process where you can take the tires, break them down, and who knows what, either reuse them or repurpose them or shred them and turn them into those little beads that they put on AstroTurf? I don't know. Is there any recovery available from the tires themselves?
Well, if cash weren't a constraint, yes, there are lots of things we could be doing with them. As you mentioned well in the introduction, this is an estate with no operations and therefore not a steady stream of cash. We do have some funding come in from some friendly parties who are making friendly advances or protective advances rather to the estate, but they're sufficient to cover the administrative costs of the estate, not necessarily to cover remediation efforts or significant remediation efforts. They're covering costs to allow a non-deteriorating situation as far as the DEQ is concerned, but they're not funding a widespread environmental cleanup effort, which is really what this site needs. We think that'll come through a sale. And so the interested parties, as we've been negotiating a prospective sale with a buyer who does have the resources and capability to clean this up, everybody's been very supportive of that approach. Not everybody, most parties have been supportive of that approach, and which, if it's accomplished the way that we hope it will allow a remediation to occur, the conditional use permit to be reinstated, and risk to the public good will be removed.
So what happens in this circumstance? You say that there's testing that is occurring on a weekly basis. Presumably, at some point, there's at least a chance that the testing shows a deterioration in the circumstances.
Yeah.
And if you're still installed at that point, does remediation become a requirement? I mean, and again, I think you mentioned this is a state court receivership, so the federal regulatory regime may be affected by it.
Yeah.
What happens in that circumstance if they determine, or if someone who's watching is in another case where they've had a determination that there is, some kind of problem, whether it's an invasion of the water supply or something else?
Yeah.
What do you pivot to as the receiver?
Well, let me just first address the good news is that it's being tested so frequently that if an offense is found, it will be found early enough that the remediation is probably tens or hundreds of thousands of dollars, not millions of dollars, which is more palatable to any party to help mitigate that risk. So we sleep somewhat well at night knowing that the frequent tests will show the first signs of failure, not the last signs of failure. With respect to the second part of your question as to kind of the state versus federal reach, yeah, it's a concern. We have a very open and active dialogue with the regulating bodies, the DEQ and the county. They've been good to work with. One possible problem, if there are found to be additional breaches, the estate would be subject to additional fines that we would need to determine in what priority those fines would be paid following a sale or availability of cash. But I think that's probably what the exposure would look like. Again, we were very careful to draft into the order appointing the receiver protective language in favor of the receiver. I personally don't want to be stuck with a battle with the DEQ or others, and we feel fairly confident that that would hold up in either a state or federal court.
So you've got this whole circumstance that's evolving and hopefully contained, but evolving over there on site, the physical plant itself and the deterioration. And that's a lot. It can keep you busy and keep your hands full, but you also have litigation. What's the receiver's participation in that litigation? And are you fielding spears being thrown in your direction from the various disputing parties from time to time?
Yeah, it's an open case, so I can't necessarily speak openly about litigation strategy. Of course, the appointment of the receiver came by virtue of a complaint between two disputing parties that both sides are members of the entity that owns the landfill property. And we're supportive of a resolution to that dispute. We think a litigation works in the best interests of all parties, not only the plaintiff and defendant, but also the lender, the environmental authorities, the county, the public good. So we're supportive of a swift resolution. Where that dispute sits, it's likely that the dispute will survive the eventual sale of the real property and equipment, and I'm sure will play a role there. But our priority right now is for the public welfare, getting the situation remedied and in the hands of somebody that can take better care of it.
And at the time of your appointment, am I correct to assume that there wasn't a sale teed up already?
No.
So you've had to work fairly quickly. You said you were appointed in September. Sounds like you may already have identified a buyer.
Yeah.
That's really an enormous advancement of the cause of this case, is to that quickly find, which I assume, and you can confirm or deny, but I assume not just anyone can buy a landfill. You have to probably have licenses and clearances and regulatory oversights and various things. Tell me about how you went about finding a buyer.
Yeah, it's a great question. It was all hands on deck. We realized the short fuse that this thing is running on. And you're right, the likely buyer here is really an existing landfill operator. And so the thought of going out to market through a traditional marketing process or even an auction process probably isn't going to yield any more interested parties than those we would find that we know operate landfills. And we had a pretty good book of prospective buyers, knowing who the big players are in the US as well as the regional players. We just started making phone calls. There have been operators that have been interested in this site for a long time, have been following its progress, that were aware of it. And we engaged in discussions with several of them and ultimately struck a deal with one we just entered an APA on last Friday, filed a motion to sell last Friday, and it's set for hearing on December 17th. But you're right, it wasn't a traditional auction or a traditional marketing process that you would expect in a receivership that doesn't have some of these issues attached to it. It had to happen fast. We knew the likely buyer was a small basket of potentials. And the other thing that I'll comment on is we need to demonstrate to the court that this offer is highest and best value or fair value, that the markets had an adequate chance to speak to it. To do that, we paid a little extra to get an appraisal and got an appraisal on the land that put the value at a place that we believe the judge will determine the sale, the prospective sale is made for fair value, that the appraisal anchors us there. And we also gave several parties an opportunity to put forward their best offer. And we received several offers, and we chose one that we believed maximized value here.
Well, and it sounds like the motion was only recently filed, but if you had to guess, would you anticipate that any of the warring ownership parties will complain, sales too low, that's a bad idea, the receiver's giving away the store, those kinds of things that we see a lot in receivership?
We're bracing ourselves for a battle on December 17th. Yeah,
Okay.
we're expecting some objections. We believe, and we structured the APA and the motion in a way that allows us to, we believe, succeed here. But we're bracing ourselves for a contest. Yeah.
Okay. And the sale as it's currently structured in the publicly filed papers you have, does that fully satisfy the outstanding bank debt? Does the bank come up with a deficiency? Does it return money to owners even?
Yeah, certainly will pay off bank debt. It'll pay off purchase money secured
Okay.
lien holders on some of the tractors and heavy equipment. Still yet to be determined whether money will be returned to equity. It's a function of the county and the DEQ have been imposing fines on the landfill. And depending on those parties' willingness to negotiate on those fines, that'll decide whether there are funds available for equity holders here.
And how much or how little are the disputes or the folks who would want to suggest this isn't a good option? How material is it when they themselves may have some personal stake, not only in potentially receiving money if they found a better deal, but also in terms of bonds and things of that nature that they may be subject to as the historic operators of this entity?
Yeah. Well, that's our strategy. To the extent an objection is raised, our response is show us a better offer.
Mm-hmm.
Right. And
Sure. Reasonable.
We believe the benefits here, particularly when we compute the cost of delay. The landfill is incurring additional fees and interest and penalties for each day that this remains in its current state. And so if there's to be a long protracted litigation over the price, the cost needs to far exceed where it is today to be able to make it economically viable. So that'll be our response. We're happy to entertain higher and better offers. Show us the money.
And when the conditional use permit was revoked, I know that sometimes there's a bond securing performance or something of that sort. Do you have that here? And if you have it here, how are those who are basically standing behind the bond, how are they reacting to being called upon to potentially contribute here?
Yeah, it's a big factor. There is a bond. The bond has been called. The parties indemnifying the bond are starting to get nervous. The bonding agency has agreed to a short period of forbearance while we try and nurture this sale to a closing. But there will come a time in the not too distant future where the bonding agency's patience will expire and they'll be looking to the parties to cover the bond.
Right.
And so they very much support a swift sale and exit here.
All right. So had you done either a landfill or some other environmentally distressed property prior to this case?
Not a landfill, environmentally distressed. Yes, we were involved in a laundromat, a strip mall, which had some pretty significant contaminants through a laundromat. So we're familiar with dealing with the DEQ. I think this one came to us for primarily based on geography. Well, geography and experience, of course, but this landfill is in our backyard. It's a 40-mile drive from my home, and I've got staff here locally that are on site as needed. And so it's right here where we operate, and came to us by virtue of that, not because of any specific environmental remediation issue experience that we have.
Okay. So what kinds of tips would you give to other turnaround consultants or lawyers who represent receivers when you get a situation like this that sounds to me like it has a daunting subset of very challenging variables. What kind of advice would you give to folks when they're faced with that kind of a circumstance, especially one that tracks some of the problems you have here with the environmental contamination or the federal regulatory oversight or the state and county level permitting process? What would be your kind of general tips or recommendations for folks as they approach something like that?
Yeah, I would say three or four. One is look for the exit. Is there a path to get this situation resolved? And as we considered whether to accept this, the court's appointment, we evaluated how quickly can we get out? What would a marketing process entail? And we felt like there was a path to get an exit here within the next 6 or 7 months. That was important to us, that there was a path ahead. Second, we've touched on it, is personal protections. Be sure that there's no personal liability to the receiver or to other fiduciaries that are responsible for cleaning up somebody else's mess. Nobody needs that. So that's typically done through the order appointing the receiver. Usually the state statutes have some protective language in that we can rely on. We don't in Idaho, by the way. So that's important. And then third, what's the path to get paid? Nobody likes to work for free. And so addressing up front, we're tasked with taking on a pretty hairy situation here. Let's be sure that there's a means or a mechanism that the professionals who are going to do the work get paid for their time and efforts here.
So all good advice. Well, I think we're coming up on the time marker on this, but I wanted to thank you one more time, and thank you to anyone and everyone who's watching this particular episode of Navigating Receiverships. If you ever come across a situation that is as challenging as this one or has environmental overlays, I'm sure Matt would welcome you reaching out to him, and his contact information will be associated with this video on the CRA website. So again, thank you, Matt, very much for helping with this. It was really enlightening and really fun to hear how you've kind of grappled with this circumstance.
Thank you, Eric. I've enjoyed our discussion today. Appreciate it.
Thanks so much.
Thank you for joining Navigating Receiverships, brought to you by the Commercial Receivers Association. Find more information at commercialreceiver.org and catch every Navigating Receiverships podcast by subscribing through your favorite platform today.